Hello? My shit just fully crashed. I was like, black screen, couldn't see nothing. I think my memory's fucked it. I think my RAM's fucked it. How could Judge Bo do this? Fuck Judge Bo, man. We blame Bo. Yeah, I really don't know what happened. Like, all my shit just fucking crashed. And then I got a black screen and I couldn't do anything. All I could hear was fucking Judge Bo echoing in my ears, like, you okay? And then I just had to, I literally couldn't do anything. So I had to turn my PC off and restart. Definitely something the DOJ would do to the marshals. I need to put this in a format to send to the Weiss, because he is currently the director. And I'm gonna cancel this and reload in. And what I do, I'm gonna run to the loo. Yeah, I don't know why. I've got 32 gigs of RAM. I think. Wait, do I have 32 or 16? What do I have? Hold on. Bear with me. Bear with me. I definitely know what I have. I do. I've got 32 gigs, but it's fucking, my shit's dying on me. And there's no way GTA is using that much along with OBS. There's no way. I think it's got to be fucked up somehow. I'm not a big PC person, so I don't know how to like diagnose what's wrong with it. But it doesn't make sense for this shit to be crashing so much. All right, I'm back in sec chat. I'm back. Is GTA a single core optimized game? Really? I had no idea. I definitely need to upgrade my GPU. For sure. think my CPU is fine. I just need to see if my RAMs have an issue. I might figure that out tonight. I'm just crashing all the time, I think, because like my UI and shit's crashing too, because it's like a memory issue. I'm 90% sure. Right, will we get to Judge Bow? Eventually. Fucking hell, he's scary. No. What did you do to me, man? Judge Bow. Judge Bow. Hold on a second. Let me run outside.
Sorry, I thought it'd be funny if I did that.
You're joking me.
Yeah, I know. Did you get to search me, or?
No. What did you do to me, man?
I don't know. Search me again. See what happens.
We're good. He's got a flag and some. Why have you got just random cash?
I just like to keep some cash on me just in case, you know, I need it.
Why have you got a new number, by the way?
What do you mean?
You got a new number?
Yeah, I like to get my new number all the time.
Why?
Just a thing I like to do.
Me?
Keep everybody on their toes.
Who?
Everybody. Oh my god, am I under arrest?
Come with me. Oops. Come in here. Take a seat, please, sir.
I'd rather stand.
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 Please. Please take a seat.
I'd rather stand.
Please. Please, I insist. Take a seat.
I'd rather stand.
Please take a seat.
How about you take a seat?
Please take a stand.
Okay. Yeah, I'll sit down.
Perfect. Right. To clarify, before we start, the reason that I brought you down is just to ask you some questions regarding an incident which occurred 10 days ago. Yeah, I do. You like some?
Yeah, please.
Okay.
What is it? Oh, it's a glizzy.
With no onions on it, because they wouldn't give me onions.
Yeah, nobody who likes onions. What is this? A Chicago dog? All right, keep going. Sorry.
It was on the 13th of January, so that's what I'm going to be asking you about. So do you need a minute to remember that day, or
I have no idea what you're talking about.
Okay, I'm just going to get started. Right. I'm going to read you Miranda rights once we're on recording. I'm just going to set up this device right here. Great. Just to check before we start so we don't waste each other's time. Are you waiving your right to an attorney?
Well, I don't think there's any other attorneys awake.
I'm sure you can represent yourself. That's not me telling you to represent. I'm just saying you seem very capable.
Yeah.
Right, okie dokie. Right, this recording.
Is that the new X250 with the added dongle feature?
Damn right it is. Marshall Special. We got money for this stuff.
Damn, you guys are rich. Holy hell.
Right, this recording's going to be starting at 16:16 UTC on the 23rd of January 2025. This is State Marshal Richard Doak. I'm joined by one Judge Bo. Is it Button or Sutton?
Button.
But Judge Bo Button. Okay, perfect. All right, Mr. Button, at this time, you do have the right to remain silent. If you do or say can and will be used against you in a court of law. You have the right to attorney if you cannot afford one, will be put by the state if available. Do you understand these rights as I've read them to you?
Uh-huh.
And are you waiving your right to an attorney before I ask you questions?
I'll be representing myself at this time.
Okay. Okay, Judge Bo. The events that I'm going to be referencing occurred on the 13th of January. That's going to be 10 days ago. I believe, correct me if I'm wrong, you were at the PD meeting to do to try and get votes for judges. Do you remember that?
I might have showed up just to talk.
Yeah, I think you were talking.
Mhm.
What were you talking about? Was it?
Probably just about myself.
Yeah, I think that sounds about right. I think you might have called me. I can't remember. Either way,
If you can't remember, I can't remember.
yeah, it's a rough one. Listen, the reason I'm asking the questions here is: do you recall a conversation you had with Sonia Summers that day?
Sonia Summers?
Sonia Summers.
No.
Okay, you don't remember?
I don't I'm gonna be honest with you. I don't even know Sonia Summers. I don't think I've ever had an interaction with her.
I've never had an interaction with Sonia Summers.
Not that I recall.
Okay. Well, you called her on the 13th,
Okay.
and you saying you don't remember this call?
Can I be honest with you?
Sure.
During my campaigning for the election, I probably called 350 people. I
That's a
would
lot of
literally
people.
go down the lemon list and just call everyone trying to campaign and get votes.
Okay. All right. So you don't remember anything about Sonia Summers?
I don't
from
remember the
this day?
specifics. It literally, like, I would just call people. I would say, "Hey, can I get your vote for Judge Bo Button?" And they would either say yes or no, and I would ask them if they needed any questions, and then that would literally be the entire conversation. I probably had 350 of those conversations over the couple weeks.
Okay. All right. Separate question. You know Barrick Johnson, right? You guys hang out together.
Yeah, him and I hung out for a little bit.
Yeah. Was
He helped me campaign.
Barrick Johnson at the meeting?
At what meeting?
The PD meeting where you came and did a bit.
I don't remember seeing him. I think I tried to call him and he never answered me. Or I think I
Right.
twatted out like Barrett called me and he never called me.
You don't remember the meeting?
No, I don't.
Let's have a look. Would it surprise you to find out that he was in the meeting with you that day? Yeah.
Would it surprise me? I mean, there's a lot of people there. So it'd been easily, possible for me to miss him.
Did you hear anything about Barrick on the 13th?
Did I hear anything about Barrick?
Yeah.
Not that I know of. I literally just been campaigning.
Okay.
And then I lost the election.
Yeah. Okay.
Can you believe that shit, by the way? I lost the election.
By how many votes?
14.
That's it.
How the fuck did Jana Pierce get 102 votes?
I'll be honest, I don't know who she is, so that's a good question.
I finished third place in voting.
Yeah. I mean,
I got 88 votes. That's more than anybody thought I would get. Let's be honest.
True. Keep trying, though, man. You keep trying.
Oh, I've never mind. That's irrelevant. Keep going.
No, go ahead.
No, it's irrelevant.
No, go. It's relevant. I just want to hear it from a friendly point of view. What's your plan?
Oh, I have a conversation with Arcadia later today.
Interesting. Okay, that's good. That's a good sign.
A judgeship. So.
Okay. Judge Bo on the up and up.
Yeah, it's maybe it's possible.
I voted for you, man. I was one of the 88.
Did you really? Well, I appreciate it. Thank you, Richard.
Yeah, no problem, man. No problem.
What do you like being called? Richard, Rich, Dick, Dark?
Richard's fine.
Okay, Richard.
Okay. Well, I mean, you say you don't remember the phone call, or anything like that.
I made so many fucking phone calls.
Just to check, you weren't in contact with Sonia Summers.
Say that again.
So you weren't in contact with Sonia Summers.
I mean, I'm saying it's possible there was a phone call, but I don't remember the what's the word? the what's the word I'm looking for? The brevity of the conversation. The brevity is not the word. The substance of the conversation.
Substance, yeah. Okay, I'm
It
gonna
probably
hash.
had to do. I mean, I'm guessing it had to do with trying to get her to vote for me,
Yeah. Okay.
as I tried to do. I mean,
All right. I'm gonna ask the hard question here. Were you
okay.
assisting anybody in the attempted kidnapping of Judge Barrick Johnson?
No.
All right. Okay. I'm glad I've got that your statement on record. Would you consent to me spinning your records for the 13th? Your phone records, that is.
Yeah, I don't see a problem.
Okay, perfect. Thank you very much, Judge Bo. That's going to be everything. This interview's going to suspend it at 16:22. Well, look how easy that was, sir. I knew you had nothing to worry about.
Now, you asking me why I got a new number looks very suspicious now, doesn't it?
Doesn't it just? Doesn't it just?
That's fucking hilarious.
You know, I hope you get hired so that I can look into you.
You what? Oh, fuck. Now that you ask me those questions, yeah, that looks very suspicious, doesn't it?
Mm-hmm. Well, Judge Bo, I hope you enjoy your day with your burner phone.
It's not a burner phone. This is my phone.
Why did you get rid of it? Why did you get rid of your number then?
I swear to God, I just like to change my number every couple weeks.
Of course.
Because people call me dumb fucking questions.
Yeah, probably because you spammed them up. You spammed everybody.
Yeah. Dude, what am I supposed to do? I'm trying to win an election.
Well, I mean, yeah, I mean,
I literally was trying to win an election off word of mouth with no signs. Everybody was fucking signs up everywhere, and I hated that. So literally, I was trying to win an election off word of mouth. The only thing I could do, I swear to God, I would wake up at my apartment for an hour, and I wouldn't leave the apartment, just calling everybody in the lemon list, and then I would hang up.
Wow.
Literally, I would spend an hour a day sitting in my apartment trying to. It was incredible. I still lost.
Well,
that motherfucker Moose Knuckles beat me.
Yeah, he did.
He didn't even campaign.
Yeah, but he's a clown.
Yeah.
Yeah.
What am I supposed to do?
Yeah, that's a good point, man. It's a good point. Well, hopefully that talk with Arcadia goes, you know? Well.
Yeah.
Yeah.
Hopefully I don't have to commit seppuku.
Please don't do that.
If I don't get appointed, I might have to.
Please don't do that. What am I doing? What am I doing? What am I doing? Grayson. Yeah, the whole Grayson thing. That was, yeah, it's a difficult one, man. What does this say? Recent verdicts. Recent trials and bench trial verdicts are not to change our procedure. Keep pressing hot gun charges. Tell them to take it to bench or appeal if they don't like it. Keep frisking if they are accomplices, etc. Terry v. Ohio, Wyoming search and seizure legislation. If a suspect has an EMP launcher, it does not remove their weapons license, but it is illegal to possess. So PD aren't changing what they're doing. What's the... Let's have a look. Common law. Common law. This document is a list of cases in which the verdict sets a precedent, which will, going forward, be considered common law. These common laws will result from verdicts in bench trials or docket cases, so a record of them is easily accessible. Common laws are not exempt from being reviewed, argued, or amended in the future. The current list of foundational common laws that are used as references from the U.S. states within the state of San Andreas are as follows. Right? The current list of common laws found by the courts within San Andreas. This is what I mean. So I'm saying that he could have found them guilty. He could have found them guilty and put this into common law. Now, I think his argument was that based on judicial powers codified, that he couldn't. Because something judge. Common law. A body of law developed by decisions of court instead of law that has been entered in such as charges. It is up to a justice to declare when a verdict is being entered into a state's common law. So in other words, he could have found them guilty on the hot gun and then a justice could have entered it into common law. Or he does something like he puts the trial on hold and speaks to a justice and then goes from there and wants to put it into common law. I don't know. Now I'm thinking, now I'm like, okay. Now I'm thinking, is there any other common laws in the US that we apply but aren't written down? Let me have a look. This is not what I'm looking for. Case laws. Fuck. How do I find the important ones? Important case law. No, USA. Not fucking UK. Yeah. Landmark United States Supreme Court cases. Well, I mean, that's kind of one. Marbury versus Madison. Who can ultimately decide what the law is? It is explicitly the province and duty of the Justice Department to say what the law is. Hold on. That one isn't in here, guys. No, I'm joking. All right, let's have a look. These are all like ones I haven't seen before, I'll be honest. What is this one? See, some of these are like covered by the Constitution, I think. The greatest hits, yeah, pretty much. Let's have a look at the Constitution. What is the difference between Gideon versus Wainwright? Wainwright and Miranda v. Arizona? Because Gideon versus Wainwright says, does the Constitution require that any individual charged with a felony but unable to pay for a lawyer be guaranteed the free assistance of legal counsel? So what's the difference in that and... Oh, hold on. I found one already. I think it. In the Constitution, there is nothing listing the right to, like, a lawyer, right? This one's a bit of a complicated one, to be fair. There's a right to a fair trial and due process, but there's nothing saying that you have a right to a lawyer. And then Miranda v. Arizona is covering, is basically saying that the police are constitutionally required to, like, inform people of their rights to remain silent and to an attorney. But Miranda v. Arizona must reference Gideon versus Wainwright about having a constitutional right to an attorney, but then we haven't got a constitutional right to an attorney. I don't think Miranda v. Arizona says that you have... I don't know. Yeah, that's my point, is that there's nothing that says a lawyer has to do it for free. That's a complicated one. I'm not going into that one. That's too complicated. No. Okay, these are not a good one. Like, where's fucking Terry v. Ohio? We're learning. We're learning. I'm sure there's ones that we do. Like, I refuse to believe there is no case law that the police currently apply and the DOJ accept that do not include, that we haven't got listed down. What's this one? What's this one? Dude, some of these are, like, so similar. Like, Arizona versus Grant is basically saying that you can search the glove box if the arrestee was in reach and distance of the passenger compartment. So what's the difference between that and Wyoming versus Utah? Anyway, we got Carroll versus United States. That one's too confusing for my brain. Yeah, Miranda v. Arizona only covers, like, the statements you make. Not this one. I don't know whether we do that one very often. Like, searching a property with consent of a third party who at this time of entry reasonably believe has, like, ability as common authority over the premises. Do we do that? Do cops do that? Nah. I want one that's like this. I guarantee there's some fucking shit that we do. Wait. Hold on. Is the hold on. I think I found one. But I don't know what about Brady? What about Brady v. Maryland? The Brady violation. What about that? That's not in common law. And yet fucking judges all the time are like, hey, don't you fucking withhold evidence that... So in other words, hey, PD, start fucking suppressing evidence. Just start doing it. Just start ignoring the evidence, man. Just hide it. If it's good for the other side, just fucking hide it, guys. It's written and not put in since the court case. Hey, that's not fucking there. I ain't fucking doing it. We need to make a fucking... We need to write this shit down. Because I will forget. Not written. Can't get me for that one, guys. Brady... What's it called? Brady versus who? Maryland. Hold on. Maybe it's not in the common law. Maybe it's in due process. I want to check. Heinous Act, habeas corpus, investigative hold, common laws. Okay. Nope. There's one Brady violation. If I go on NoPixel, the forums, and I search for Brady, let's have a look. What we got? Has there been any like rulings on it? So there is one here in October, which is to do with Finley, Milton, and Nana Banana. But Judge Weiss said the defense's motion to apply persuasive authority regarding the Brady rule is denied. It's not recognized as binding case law. Then it says the ruling in the People versus Dominic Rhodes was reached independently of this case law. So in other words, it sounds like the People versus Dominic Rhodes should have been entered into common law. Right? That's what it sounds like. But it wasn't. Have a look. Oh, there is. Is there anything mentioning common law in here? Oh, here we go. This court will be discussing with the judiciary the potential to institute case law based on the outcome of this case regarding what is commonly referred to as the Brady rule. Yet it wasn't instated, and as such, is stupid. As such, is stupid. That was not put in. Okay, I feel like there was more that popped up. Finley Milton. Do. The court strongly emphasized that officers must be trained on their obligations under Brady, as the withholding of exculpatory evidence is not just an internal matter, but a constitutional issue that can undermine public trust in law enforcement and the legal process. Hey, it's not fucking there, man. It's not fucking there, so they don't have to do shit. Is there another one? Hold on. Oh, this is back in April now. So I don't want to go too far back. Okay. So that's the Brady one. That should not be enforced at all by the DOJ. What else? What else we got? Let me think. What else do we do? Hold on a second. Hold on a second there. Whoa, DOJ. Hold on a second there. What have you been doing? Have you been violating people's rights without a common law? Whoa. Because I'm looking at Map v. Ohio. Which says... Let me get it. That all evidence obtained by searches and seizures in violation of the Fourth Amendment is inadmissible in a state court. The decision launched the court on... So when they're saying that warrants should not be legal and they throw them out, that doesn't, because this case law doesn't exist, that means they shouldn't have thrown out the evidence either. Because they didn't have the common law. Even if that evidence was obtained illegally, they're fucking good. It doesn't matter. Here's another one, man. This is the stupidity of writing everything fucking down. Quoting. I'm quoting. Okay. So I'll make my point. Write it down so I don't forget. And throws evidence out of court. Hey, given that this common law does not exist in legislation, all of that evidence would still be admissible. This is the fruit of the poisonous tree. This is literally the fruit of the poisonous tree legislation, I think. Fruit of the poisonous tree case law. Have a look. Holy fuck, this is a 27-page document. What the hell? Yeah, map v Ohio. Oh, there's another one. Isn't that written somewhere? I don't know. Good question. That's my point. Is it's expected that shit gets thrown out. I mean, maybe it's in search and seizure. Wait, I ain't fucking put this in a document and let me search it. What the fuck? Control F. Admissible. There's nothing about admissing evidence. Nope, nothing. Illegal. Nope. There's nothing. There's nothing in legislation about throwing out that says if evidence was found from a legal search warrant that it has to be thrown out to court. Let me check the due process. Fuck, I've lost it. This is Pandora's box. This is absolutely Pandora's box. If anything, if evidence is found to be from an illegal search warrant, then a mistrial needs to be called. I don't see anything here. I don't see anything here about evidence being thrown out. So there's another one. Uh-oh. Right, let's have a look. Is there any others? I think we just need like 2 or 3 to just prove the point, you know, of silliness that here. Honestly, I might include the Gideon versus Wainwright. So the U.S. Supreme Court ruled that an indigent defendant has a right to court-appointed counsel in non-capital cases as well as capital cases. So in other words, Miranda v. Arizona is just a warning, but it references Gideon versus Wainwright because it's like you can get a lawyer if you can afford one. Don't say any. Don't say any. I don't want to use chat as much as you guys are like a fucking hive mind of information. No, not that one. What other ones do we use? I recognize this one. I wish we did traffic court because Ren versus US is absolutely used. This is the thing. It's like I could go through all the rulings and just be like, okay, this was ruled, you know, using this. Honestly, I might do that. I might do that because we've got to point out this. I just hate the whole writing down thing. Everything has to be written down. You know? God, Jesus, some of these I'm reading are fucking crazy. Give me a second, chat. More cases you had, less cost of investigating at the court. Yeah, you're probably right. For sure. I think I'm looking at this the wrong way around. I'll probably have to look at the verdicts made. I don't know why. If I search common law, let's have a look. On the DOJ. Oh, something was posted yesterday about judicial positions, powers, and election process legislation. Following legislation proposal, this was presented to combine and replace. Oh, it's combining and replacing both. Let's read this. This seems interesting. So the DOJ are trying to combine both the judicial hiring and election process and the judicial powers codified legislation. Okay, I don't care about all the top stuff. Judicial elections. Okay, sure. Judicial appointments. The DOJ may appoint magistrates, judges, and justices as necessary to ensure the efficient operation of the judiciary.
Magistrates may be appointed by any sitting judge, provided they meet on. What's a magistrate? I actually don't know. What's the difference? We've got magistrates in the UK. What's the difference between a magistrate and a judge, chat? Judges may be appointed by a majority voting and sitting judges. Justices may only appoint by a unanimous vote of all current justices. All right. Magistrate has less power. Okay. Appointed members of the judiciary must adhere to the same ethical standards expected of elected officials, ensuring fairness and pass. Yeah, okay. The magistrates can conduct bench trials, issue licenses of open or small claims court, traffic court proceedings. They will have the following powers: granting and denying motions, judicial discretion. Yeah, contempt of court, criminal verdicts, summary judgment, sentencing, civil verdicts, expungements, and other powers. Sure. Judges, in addition, can do preliminary injunctions, temporarily prevents the party from taking action until the case is resolved, maintaining the status quo to prevent irreparable harm. No contact orders, receivership, appointing a receiver to take control of an asset or property in dispute. Cool. This might already exist, and I just haven't seen it. Writ of mandamus. Command the public official or government entity to perform a specific act required by law. Writ of prohibition. Directing government entities to stop actions outside its jurisdiction. Well, there's Pred's happy seeing this, the difference between the two. Sanctions, sure. Bail decisions, sure. Permanent injunctions. Permanently prevent certain actions. So I guess that would be like a judge could rule that an individual would never be able to run for office or something like that, I guess, or like never be able to hold a gun, you know? That might be constitutionally difficult, but order specific performance. That sounds strange. Compel a party to fulfill contractual obligations where monetary damages are inadequate. Review and approving legal instruments ensuring due process. Magistrates may engage with these only under justice oversight. Appointed judges may have additional powers granted by specific legislation. Sure. Justices control DOJ finances. Enacting legislation. Common law presidents establishing rulings as part of the state's common law. Appellate review, overseeing appeals from previous rulings. Modification of penal code. Adjusting laws, fines, and penalties to ensure they remain effective and compliant. Conduct hearings to assess misconduct and decide on disciplinary action. Sure. Justices may censor, suspend, fire, and or provide other punitive measures to members of the judiciary. Elected magistrates may only be removed through impeachments. That's strange. Why? Wait, so judges can be removed by the justices, but magistrates can't. Even though they're appointed by a sitting justice. Okay. In cases of disagreement among justices, decisions shall be made through majority vote of the justices unless otherwise required by legislation. Delegation of powers. They can delegate, assign, or grant specific powers or responsibilities to magistrates or judges as they see fit, ensuring the judiciary operates efficiently and flexibly. Must be documented. Judicial officers may be removed in the following procedures. Appointed magistrate and judge may be removed with appropriate cause by a justice. That conflicts with that line. Unless it's because this says elected. I think it says elected. The removal of a judge requires a majority vote by citizen justices with a 24-hour voting period to tabulate results. Elected magistrates may only be removed through the impeachment process. Justices, however, may only be removed via an impeachment hearing overseen by the state of San Andreas. Justice says the oversight for the judiciary must maintain strict adherence to disciplinary guidelines. Penalties such as censure, suspension, or firing must be administered based on internal procedures. Any conflicts among justices must be resolved by a panel with the majority vote deciding the outcome. Okay. And it's on the 72-hour contest period. I mean, again, there's nothing saying that a justice can throw out fucking search warrants. Again. Yeah, I don't know. I want to see what's different about this. Between this one and... Where is it? Let's have a look. And this one. This is like... I feel like these are a lot longer. Like all the descriptions and shit. Yeah, it's not in here. I think it definitely does shorten it down for sure. Yeah. Oh, I just got an email. Hello, Doc. Good morning. Just woke up to this on my desk. I would love to lay eyes on if and get your opinion. Have a look. Browser. I'm gonna make a copy. Someone's doing things. Actually, what am I doing? Am I editing? I'm worried I'm editing. I think I'm editing. I'm gonna make a copy. Hot guns and an affirmative defense. The Constitution of San Andreas 9149, right to fair trial and due process. All citizens are guaranteed a fair trial and due process of law. Judicial power codified. 14031. A formal decision made by a member of the judiciary determining whether the defendant is guilty or not guilty of the criminal charges brought against them based on evidence presented to them. Right? San Andreas Department of Justice holds that as long as due process and a fair trial are not infringed? Impinged? I think it's supposed to be infringed. Some affirmative defenses are required to mitigate sentences in capital level offences. They then hold that in relation to other charges, specifically here in reference to hot gun related charges, when affirmative defense can be used to prove the innocence of a defendant, that they shall from this point forward be required in these instances. Why is this written like this? A hot gun is a weapon proven through evidence beyond a reasonable doubt to have been used in commission of a crime where the suspect was not detained or arrested on scene, but was arrested afterwards while in possession of said hot gun. Okay. Bit of a long sentence. The state of San Andreas now requires you to offer an affirmative defense to explain how, why, and when you came into possession of said weapon. To prove you did not commit the crimes now attached to the weapon within your possession. This is no way infringes upon the defendant's Miranda rights. This is merely the standard within a court procedure should the accused wish to offer a defense for the crimes alleged. This affirmative defense should be judged on a balance of probabilities. This is the codification of a standard that has been held in San Andreas courts for years. I think the issue here is that if I was a criminal defense lawyer, seeing this tried to get pushed, body of law developed by decisions and court rulings, instead of law that has been enacted into statute by legislation or charges, is up to the justice to declare whether a verdict is being entered into a common state's common law. Doesn't that inherently suggest that the verdict of a hot gun needs the subject to be? Because what Grayson was saying is that basically he doesn't like the affirmative defense thing, and it should be on the prosecution to prove that that person was in possession of that gun at that time. And that's what the verdict is. Let me check that I'm saying that right, because I want to go check his thingy. I'm pretty sure that's what he's saying. And so the verdict of that case is not this case law. Because this case law is the opposite to what he said. So he said, we have over years entrenched the position that hot gun charges stick without an affirmative defense against them. I see no legal authority for that position within legislation, the Constitution, or anywhere else. It's just been a pattern of behavior and common law, but common law that is not codified or entrenched within our body of law. Mr. Hendricks pled guilty previously to possession of firearms used in some of these crimes. There is very little else providing evidence of culpability. Without legal doctrine explicitly leading towards a reversal of the burden of proof when someone has possession of a hot gun, I am loath to enforce it. Because of the DNA found on scene and the possession of a gun used on scene, the charges of accomplice, I can see why Mr. Hendrick was charged. I, however, believe he would have been more fittingly charged as an accessory rather than an accomplice. Okay. So, yeah, Grayson... Yeah, so... I think the issue is here. Grayson's verdict was that the burden was on the prosecution to prove that Mr. Hendricks was in possession of those guns on those scenes for him to get those charges, right? And yet this new legislation that is being proposed, this common law that's being proposed, the People versus Future Hendricks, is saying the opposite. Unless I'm misunderstanding here. Because this is saying some affirmative defenses are required, right? The state of San Andreas now requires you to offer an affirmative defense. So yeah, it's the opposite of Grayson's verdict. And so I don't know whether that's legit or not. Because of this line where it says it's up to a justice to declare when a verdict has been entered in our state's common law. Honestly, I don't know whether we can like nod and say, yeah, that's good. I think it's good. I think it's a good legislation, a good common law, but I don't know whether they can enact it. So Grayson said she got this on her desk. So does that mean it was written by Grayson? That wouldn't surprise me. I wonder if she's around. No, Doc's not going for judge, no. It's just that this